Hello, Professor Maddie and OL 682 classmates. Our team has prepared this presentation on minimum wage and the complex issues surrounding it. Few concepts in business today are as polarizing on the national stage as the minimum wage. For it or against it, many people hold strong opinions. It is not high enough or it is too high. It is the key to a living wage and lifting people up out of poverty, or it will destroy small business. It boosts real employment by providing jobs that can support a family, or it increases unemployment and jeopardizes a robust economy. Like most complicated concepts, there's an element of truth in almost every position one sees in the public discourse, with few clear answers from economic studies. The minimum wage was born out of the Depression. The country emerged from the Depression under the New Deal programs of President Franklin Delano Roosevelt. One of the key programs FDR instituted was the National Industrial Recovery Act. In turn, one of the agencies created by the NIRA was the National Recovery Administration. Excessive competition within similar industries was seen as one of the contributing factors of the Great Depression. Reduction of harmful competition was seen by FDR and his appointed leader of the NRA, Hugh Johnson, as a means of enticing the economy to grow while ensuring that the base of the country's economic engine, American workers, shared in the recovery. The popularity of the NRA and its industry codes fluctuated greatly during its brief lifespan. On the onset of the program, public support swelled behind the program and its promise of recovering the economy while improving working conditions and wages for employees. The public's excitement for the NRA and its trademark Blue Eagle was exhibited in a well-attended parade through New York City in the fall of 1933. Each industry developed its own standards within the benchmarks of the NRA. The minimum standards set by the NRA were work weeks of between 35 to 40 hours, at least $12 to $15 a week, and a prohibition against hiring juveniles under the age of 16. Industries were free to develop codes of employment that exceeded the minimum standards of the NRA. Of particular note is the standard set by the cotton industry, known as the Cotton Textile Code. It mandated wages of $13 a week in the North and $12 in the South, with a 40-hour work week and no child labor. The code was specifically cited by President Roosevelt, who stated that the code made him happier than any one thing since I have come to Washington. Contrary to natural intuition, the business community as a whole was not the greatest barrier to establishing a minimum wage. The United States Supreme Court was the principal hurdle for President Roosevelt to surmount. Starting with the 1905 case of Lochner v. New York, the United States Supreme Court established itself as the principal opponent of minimum wage and other working condition laws throughout the United States. The case came as a result of a violation of the 1897 New York State statute prohibiting employees in bakeries from working more than 60 hours a week, known as the Bake Shop Act. Joseph Lochner was fined and eventually sentenced to incarceration for allowing an employee to work in excess of the 60-hour limit. The case which served to dissolve the NRA was the case of Schechter Corporation versus United States. On May 27, 1935, a day that came to be known as Black Monday, the court decided that a state law allowing for the regulation of conditions in chicken slaughtering houses was an unconstitutional delegation of government power to private interests. In the 1936 case of Joseph Tipaldo, Moorhead versus New York, the Supreme Court entrenched itself further in its position against minimum wage and working conditions laws. Mr. Tipaldo was arrested for violating the minimum wage laws of New York State in the operation of his laundry business. President Roosevelt viewed his resounding victory in the 1936 presidential election as a referendum on the public's consent for his New Deal program, including minimum wage legislation. Emboldened by his decisive victory, President Roosevelt issued a challenge to the Supreme Court that he would personally add 6 new judges to the court so he could shake loose the 9 incumbent judges' staunch positions against workers' rights. The Fair Labor Standards Act became law on June 25, 1938. President Roosevelt signed 121 bills, one of them being the landmark law in the nation's social and economic development, known as the Fair Labor Standards Act of 1938. In its original form, the FLSA applied to a variety of industries that combined covered approximately 20% of the labor force in the United States. To provide for a smoother transition to the new minimum standards, the wage hour and work week restrictions were phased in over time. The FLSA prescribes standards for the basic minimum wage and overtime pay and affects most private and public employment. It requires employers to pay covered employees who are not otherwise exempt at least the federal minimum wage and overtime pay of 1.5 times the regular rate of pay for any time worked over 40 hours in a work week. Contrary to popular belief, not every worker is legally entitled to the federal minimum wage. There are significant categories of workers that are exempt. So-called white-collar workers are exempt from certain provisions of the Fair Labor Standards Act, including minimum wage and overtime pay. In order to determine if a position is exempt, a duties test is applied. These jobs include executive, administrative, and professional employees, including teachers and academic administrative personnel in elementary and secondary schools, outside sales employees, and certain skilled computer professionals. Other positions are specifically exempt by their job categories. The opportunity wage allows employers to pay employees under 20 years of age a minimum wage of not less than $4.25 an hour during the first 90 consecutive calendar days of employment with an employer. A unique category related to minimum wage is that of tipped workers. Employers of tipped workers are only required to pay $2.13 an hour in direct wages if that amount, plus the tips received, equals at least the federal minimum wage. The employee retains all tips, and the employee customarily and regularly receives more than $30 a month in tips. Employers must make up the difference if an employee's tips, combined with the employer's direct wages, do not equal the federal minimum hourly wage. As mentioned previously, there are some important tests, known as duties tests, provided by the FLSA to determine whether or not an employee is exempt from minimum wage and overtime pay provisions. Workers employed as bona fide executive, administrative, professional, and outside sales employees, and certain computer employees qualify for the exemption, provided they meet certain tests regarding their job duties and are paid on a salary basis of not less than $450 per week, known as the salary basis requirement. There are also exemptions for outside sales workers and highly compensated employees. According to the U.S. Department of Labor Fact Sheet 17A and 17G, job titles do not determine exempt status. FLSA exemptions specifically do not apply to skilled trades like carpenters and electricians, or police, firefighters, paramedics, and other first responders, no matter how much they are paid. The current federal minimum wage is set at $7.25 per hour. According to the National Council of State Legislatures, 29 states and Washington, D.C. have established minimum wages exceeding the federal minimum. These localized minimum wages are often driven by an increased cost of living or local politics. A discussion of wages is not complete without mention of overtime pay. The FLSA mandates that employers pay employees at least 1.5 times the regular rate of pay for each hour worked in excess of 40 hours in a work week. The FLSA does not limit either the number of hours in a day or the number of days in a week that an employer may require an employee 16 years of age or older to work, nor are there limitations on the number of hours of overtime that may be scheduled. As with the minimum wage, there are certain categories of employees who are exempt from this requirement. In several recent cases, the government has penalized company workers and officers for failing to pay overtime, imposing stiff fines and even imprisonment. Under the Fair Labor Standards Act, any employer who violates minimum wage or unpaid overtime compensation laws may be liable for both the shortfall and liquidated damages, meaning a punitive payment of double the damages. The FLSA definition of employer can be very broad. Along with supervisors and high-ranking executives, it can also include officers and directors of a business. To avoid both FLSA violations and personal liability, employers need to be sure they comply with all relevant minimum wage, overtime, and other salary and benefit related regulations and agreements. Otherwise, they may find themselves paying a steep price. There are many opinions and contradictory statistics as to who is really working at the minimum wage. The official government numbers are arrived through a report from the United States Bureau of Labor Statistics entitled Characteristics of Minimum Wage Workers. According to this report, in 2014, the most recent period for which data is available, 3.9% of all hourly paid workers were paid at below the federal minimum wage. This represents 3 million workers out of 77.2 million workers aged 16 and older who were paid at hourly wages. Service occupations represented the highest number of hourly paid workers earning at or below the federal minimum wage. The Pew Research Center has independently analyzed these numbers and arrived at the following statistics. People at or below the federal minimum wage are disproportionately young, mostly white, nearly half are women, and they are largely part-time workers. The Economic Policy Institute, a think tank affiliated with the labor movement, reported that the typical worker who would be affected by an increase in the minimum wage to $10.10 per hour looks nothing like the part-time teen stereotype. She is in her early 30s, works full-time, and may have a family to support. However, the Heritage Foundation, a conservative think tank, reported that minimum wage workers under 25 are typically not their family's sole breadwinners. Rather, they tend to live in middle-class households that do not rely on their earnings. Generally, they have not finished their schooling and are working part-time jobs. Over 3/5 of them are currently enrolled in school. Using the same data, these two very different organizations arrived at very different conclusions regarding who the minimum wage benefits. Conventional economic theory addresses labor like any other commodity, following the familiar curve showing a decrease in demand as price rises. This theory tends to hold true in a competitive job market where the labor supply is higher than demand. Many variables can come into play once put into practice. Monopsonistic, meaning single employer markets, tend to yield an increase in employment when the minimum wage is increased. The rationale for this is finding that in a monopsony, the employer can essentially set a take it or leave it wage, and some workers may opt not to work at that wage, only choosing to enter the workforce when that wage increases. This finding does not hold true in a competitive labor market because those workers are likely employed elsewhere at a higher wage. The availability of labor also affects the outcome of a minimum wage increase. In a market with a low labor supply, employers have likely already been forced by market demands to pay above the minimum wage, making any increases moot. Economists tend to disagree on the impacts of the minimum wage. Those who ascribe to conventional economic theory believe increased minimum wage will cool demand for labor, resulting in less employment. Others disagree, citing any number of variables and theories to show no change or even an increase in employment following a minimum wage increase. A notable example of these divergent opinions lies in the Card and Kruger study and the subsequent comments by Newmark and Washer. In the early 1990s, New Jersey increased the state minimum wage above the federal minimum, while neighboring Pennsylvania did not. Card and Kruger used targeted telephonic surveys to evaluate impacts of the minimum wage increase in areas of western New Jersey and eastern Pennsylvania. This study showed a slight increase in employment in the New Jersey stores. Newmark and Washer conducted a similar evaluation in the same geographic area during the same time, but used payroll data rather than phone surveys, and attempted to evaluate employment by hour rather than employee. They found an employment decrease when evaluated by hours worked rather than total number of employees. One study suggests that increased minimum wage levels lead to higher skilled workers displacing lower skilled workers. Additional evidence shows service industry employment shifting from lower skilled adult workers to higher skilled teenage workers. In retail, higher minimum wage seems to have shifted employment towards part-timers and women. Employers may be able to adjust for higher labor costs without reducing employment. A leading organization working with minimum wage policy around the globe is the International Labor Organization. The ILO was founded in 1919 in the wake of World War I to pursue a vision based on the premise that universal, lasting peace can be established only if it is based on social justice. The ILO became the first specialized agency of the UN in 1946. The vast majority of countries around the globe mandate a minimum wage in one form or another. Estimates put the number of countries that have some kind of minimum wage setting at 90%. However, approaches to establish minimum wage vary a great deal. ILO Convention number 131 suggests that minimum wage fixing should ideally involve governments, social partners, and independent experts. This approach is incorporated to one extent or another in all but 13 countries globally. In the majority of countries, the government sets the minimum wage, either following consultations or recommendations of a specialized body, such as the Low Pay Commission in the United Kingdom, or the Minimum Wage Council in the Republic of Korea, or after direct consultation with social partners, as in Brazil, for example. Other approaches include the government setting minimum wages alone, without prior consultations with social partners and labor groups, or an independent body that's established to set the minimum wage. Also, collective bargaining often takes place outside the purview of the governing body, but which nevertheless binds public policy. A trend in U.S. municipalities is the institution of a living wage ordinance, which mandates that certain employers in their jurisdictions pay their workers wages that are above federal and state minimum levels. This movement began in Baltimore in the early 1990s and has spread across the country. One criticism of LWOs is that they only affect youth, but living wage researchers have found that the median workers covered are in their 30s, work full-time, and have been working in their jobs for quite some time. These workers are disproportionately female and not white. The fact that the minimum wage has not kept up with inflation promises to keep the issue front and center of political discourse. The push for higher local minimum wages isn't just about political will. It's also about economics. Many of the cities that have passed or considered higher wages are, to put it simply, painfully expensive to live in. A $15 per hour wage makes more sense in Los Angeles than in a small rural California farming town, where rents and homes are far cheaper. Protest groups like the Fight for 15, which advocates for higher wages for fast food workers, have capitalized upon and advanced these conversations as well, helping establish in people's minds the idea of a minimum wage more than twice as high as the federal minimum. fight over the minimum wage has largely fallen along political party lines, with Democrats advocating for a higher national minimum wage and Republicans arguing for the maintenance of a lower wage. President Obama has made the goal of raising the federal minimum wage to $10.10 in the 2014 State of the Union address. In the upcoming presidential race, two of the Democratic candidates have advocated an even higher wage of $15 an hour. On the Republican side, some candidates have advocated elimination of the minimum wage. Notwithstanding any change in the minimum wage amount, there are several important takeaways for any employer to remain cognizant of in order to avoid violating this important provision of the FLSA. Be very mindful of FLSA when structuring positions. Consult an HR or legal advisor if there is any question about whether a position is subject to FLSA rules or exempt. Periodically revisit all job descriptions, particularly the ones identified as exempt. If the job as it is performed has changed significantly since the original job description was developed, its status may have changed. For global employers, particularly those in EU countries, be aware of all requirements of the Working Time Directive or other legal limitations on wage and hour practices, in addition to minimum wage laws. In addition, an employer may want to periodically assess wages against industry competitors. With the high cost of training and turnover, losing qualified employees to other higher paying jobs will negatively affect profitability more than a modest increase in wage. An employer should also pay attention to the development of living wage ordinance movements in their area of operations. Substantial increases in the minimum wage may have an adverse effect on the bottom line. An employer should be sure to consider other forms of compensation in addition to hourly wages to maintain competitive advantage as the employer of choice. Robust health insurance coverage, adequate sick and vacation time policies, parental leave, and more can increase desirability as an employer in today's labor market. We appreciate your consideration of this presentation and look forward to receiving your feedback. Thank you.